Welcome back. We've got Mr. Emeka Ngige, Senior Advocate of Nigeria. He joins us this morning. Thank you for coming on today.
Thank you, gentlemen.
Well, this is all over the place now. The Senate just categorically saying, advising the President to relieve the Customs Controller General of his position, saying that the AGF had written them saying the matter is in court. But let's understand, at what point is a matter considered to be in court and then sub judice?
Well, I think you can consider a matter sub judice if it preceded the matter on the floor of the Parliament. If the matter had been in court and then is brought to the attention of the Parliament, you can mention that the matter is sub judice. But not when a matter is being discussed by the Parliament, somebody that goes to court in order to tie their hands.
So Dino Melai is right?
Yeah, he's right. He's right. Otherwise, you mean that the Parliament cannot function. If you go to court, they will stop deliberating on the matter. That will infringe on the principle of separation of powers.
So that now takes us back to the point at which he's been asked, the CGC was asked to appear before the Senate. Do you suppose that it's the right thing for him to do now, instead of going the way of his lawyers who have told him that this case is sub judice?
Well, you know, interpretation of law at times can be subjective, depending on how you appreciate the issue. His lawyers may have advised him based on their own understanding of the law and also to meet the interests of their boss or their client. But for me, I'm speaking here as a neutral party, that if the Senate is considering a matter and a third party goes to court to make the issue under discussion in the Parliament a matter for consideration by the courts, you cannot turn around to say the Parliament cannot continue discussing the matter. It will create a lot of problems if that precedent is followed, because a lot of things that affect ordinary Nigerians or individuals come to the Senate or to the House of Reps every day. So if I want to stop it, all I need to go to court, make it a sub judice, come back and tell them, don't discuss. It's not possible. That's why there's a separation of power. So the advice by the lawyers, with greatest respect for me, is not correct.
Because even it was the AGF who the customs boss quoted saying, well, we're acting, he's the chief law officer, so we're simply following his directive. So can the CGC do otherwise when the AGF had advised him and written to the Senate?
Well, I don't know how the AGF came into the matter, other than that he was joined as a party from what we heard. I don't know why, what led to him writing the Senate, whether it was solicited. If they solicited for his advice, then he can give them advice the way he understands the law. But writing to them suo motu, as I will say, is also not in the best tradition of law. The Senate is discussing a matter. Somebody sues the CGS, sues Attorney General. For me, all the Attorney General can do is to write to them that this matter is in court. But I will not go to the extent of telling them not to discuss. That I have been served with a process. The matter appears to be in court. I will not say don't discuss, because like Dino pointed out, it's a process. Tomorrow, if that man enters, files a notice of discontinuance, he would have aborted the hearing. And there is no court order. There is no motion for injunction. If the plaintiff in the matter has followed his action with a motion for injunction to restrain the Controller General of Customs from appearing in the Senate in a uniform, so to say, then he served the National Assembly, served the Attorney General of the Federation. the Attorney General can say, based on the principle in Ojukwu and Lagos State government, we say that where a matter is in court and there's a motion for injunction, whether the injunction has been granted or not, it will be in the interest of justice not to foist a fait accompli on the court by going ahead to decide the matter that has been brought to court for adjudication. It is out of respect to the court that that principle in Ojukwu and Lagos State government is applied, so that to show that you respect the authority of the court. And then you go to the court and argue the injunction. If you fail, the Senate will continue. But here, I'm not aware that there is a motion for injunction filed along with that writ of summons.
So it is until that is filed alongside it that the Senate can then say,
consider it that there's a motion for injunction, and the Senate has legal advisors. They can advise the principal officers that since there's a motion for injunction, you can hold on until the matter is disposed of.
Okay, well, we'll come back and continue this in just a moment. Don't go away.
When there exists on the ground facts pointing to a direction of criminality, I think no other consideration should hold water as it relates to vendetta. More so, the arrest or invasion or perhaps what I call investigation relating to judicial officers was not in any way particular about individual. It was all-encompassing, and then at the end of the day, revelations were made as it relates to commission of offense, issues that borders on money laundering. Monies were found in excess of the tolerable limit. Issues that borders on illegal possession of weapons were equally addressed as it relates to that particular case. The truth of the matter, I have to clearly say, was an issue that borders on similar allegations of criminality. And then there was a case I was handling before him that borders on, that has to do with the importation of fertilizer by a certain company. One of the company happened to be my client. And then arising from that, my client filed an application. There was an application on the other side for the sale, attachment and sale of the fertilizer. And I filed a response by way of counter affidavit to the application. That application was taken, and Justice Ademola dismissed the application of the parties on the other side as it relates to the attachment and sale of the fertilizer. In all sincerity, certain undertones relating to compromises on my part set into the process after the dismissal of the application.
Now the confirmation of the acting EFCC chairman has been rejected twice, but he is saying that he's still in charge of the EFCC, pending the time the presidency says otherwise. So what is the status quo of his continuous stay in office as the acting chairman?
Again, the background of the constitutional right of the president as it relates to the appointment or otherwise of the chairman of the Economic and Financial Crimes Commission, I wouldn't like to preempt the position of the presidency over that.